The law divides property ownership into two tangible categories. Real property governs land and real estate, while personal property covers specific physical objects like cars, stocks, or jewelry. But there is a third category of ownership. Intellectual property represents the products of human creativity, intangible assets that hold commercial value. Because IP is an abstraction, it poses a unique problem. You cannot lock a thought in a physical safe deposit vault. This lack of physical boundaries leaves intellectual property highly susceptible to commercial piracy on a global scale. Since physical locks are impossible, society must construct a rigid legal architecture to protect a creator's ownership over an idea. We can map this legal architecture by dividing intellectual property into three distinct domains. Patents protect scientific and technological inventions by granting a temporary monopoly to the creator. Trademarks shield commercial symbols and brand identities from imitation, protecting them as long as they are employed in trade. Copyright protects the specific expression of literary, musical, and artistic works. In India, this protection lasts for the lifetime of the author plus 60 years. Across all three domains, the legal system must balance a delicate tension. It has to grant enough commercial reward to incentivize creators, while preserving the public's right to access culture and knowledge. In copyright law, the boundary separating a private legal monopoly from the public domain relies entirely on the legal test of originality. Without a strict definition of what qualifies as original, basic facts and everyday data would be permanently locked away from societal use. Originality is the sine qua non of copyright law. It is the absolute essential condition for protection. This condition is enforced through the idea-expression dichotomy. As established in the Indian Supreme Court case R.G. Anand versus Deluxe Films, the law draws a hard line. You cannot copyright a raw idea. Protection is only granted to your independent, uncopied arrangement of that idea. Under Section 13 of the Indian Copyright Act, this protection extends beyond traditional art to include literary works, computer software, and compiled databases. India inherited its initial framework for this standard from the British Copyright Act of 1911, but the country transitioned to a fully independent legal standard with the enactment of the Indian Copyright Act of 1957. That 1957 statute forced Indian courts to continuously evaluate exactly where the legal line between an unprotectable idea and an original expression truly lies. Determining that line requires answering a central legal question: how much effort or creativity is required to claim ownership over a piece of information? Globally, courts have developed three competing legal tests to measure this threshold. The first is the sweat of the brow doctrine, originating in the UK. This approach focuses entirely on the diligence, time, and mechanical labor it took to compile a work. India historically followed this labor-focused test in early cases like Burlington Home Shopping. The second is the U.S. modicum of creativity standard. Established in Feist publications, this doctrine rejects pure labor, demanding at least a minimal degree of creative spark. Relying purely on the UK's sweat of the brow doctrine is dangerous. It allows individuals to monopolize public facts simply by working hard to gather them, stifling the spread of public knowledge. To avoid that trap, modern Indian law uses a third approach, the skill and judgment test, acting as a bridge between pure labor and intellectual creativity. The doctrinal pivot towards this standard occurred at the Supreme Court of India in the case of Eastern Book Company v. D.B. Modak. In this ruling, the court officially rejected the sweat of the brow doctrine. The justices established a new baseline. While a work does not need extreme novelty, the creator must apply independent skill and judgment that results in at least a minimal element of creativity. Eastern Book Company met this standard. They took uncopyrightable public court judgments and added creative architectural elements, like cross-references, specific formatting, and headnotes. We can test the limits of this rule by looking at a modern business application, the 2014 Delhi High Court case, Tech Plus Media v. Jyoti Janda. The plaintiff in this case attempted to claim copyright over a compiled database of client email addresses. The court applied the new standard. While compiling emails requires time and labor, it lacks the creative architectural skill demonstrated in the Eastern Book Company case. The court denied the copyright, ruling that the database was a mere mechanical compilation. By requiring creative skill, modern Indian law ensures that raw data compilation remains a public fact, preventing corporations from monopolizing basic information. While intellectual property rights are inherently territorial, modern commerce crosses borders instantly. To manage this, nations rely on international treaties designed to harmonize copyright laws, including the Berne Convention and the Universal Copyright Convention. The primary mechanism for standardizing global enforcement is the WTO's TRIPS agreement. Nations update their domestic laws to align with these frameworks. India executed a massive legislative overhaul in 1999 to comply with these international standards. By 2005, India achieved full TRIPS compliance. The practical commercial benefit is reciprocal protection. Through the International Copyright Order, foreign works are protected within India, and Indian creators hold legal protection abroad. This interlocking web of treaties ensures that the distinct skill and judgment applied by a creator in one jurisdiction is recognized and respected globally. Intellectual property has become a primary commercial asset, serving as an essential driver for investment and the development of new products. Indian jurisprudence has engineered a middle path that rewards true intellectual labor without locking up basic data. But in legal disputes, the threshold of originality is never assumed. It must be rigorously proven. For a modern business, understanding this precise legal boundary is the only way to protect their most valuable intangible assets from theft. The legal right of ownership is determined by creative expression, rather than the physical effort of gathering information.